Section 14, Negligent and Legal Hotline Q&A, Arizona Market Introduction, from Professional Conduct to Professional Risk. In Section 13, we discussed professional conduct under R428-1101, fiduciary duty, disclosure, conflicts of interest, competence, reasonable care, and staying within your area of expertise. Now, we move into what happens when an agent fails to use reasonable care. This section focuses on misrepresentation, negligent misrepresentation, fraud, and real-world legal hotline scenarios. These are the situations where an agent may say, "I didn't mean to cause a problem," but the damage has already been done. Misrepresentation, negligent misrepresentation, and fraud misrepresentation is a false, unintentional statement by which one party tries to gain an advantage. Negligent misrepresentation is a false statement that the broker or agent should have known was incorrect. Fraud is an intentional false statement or concealment of fact used to gain an advantage. Any of these can lead to complaints, lawsuits, discipline, or even loss of license. The story, the sewer problem. Imagine an agent takes a listing and the seller says, "The home is on sewer. I've always paid a sewer bill." The agent repeats that statement in the MLS without checking. After closing, the buyer discovers the home is actually on septic, and the backyard has raw sewage from an overflowing septic tank. That is a nightmare. The agent may not have intended to mislead anyone, but the agent could have verified the information with the county or appropriate utility provider. This is a classic negligent misrepresentation risk. Square footage. Do not guarantee what you did not verify. Square footage is another common risk area. If square footage matters to the buyer should verify it during the inspection period. Agents should avoid guaranteeing square footage unless properly verified by an appraiser or reliable source. In Elm Retirement Center LPV, Callaway, the buyer alleged reliance on advertised square footage, but the purchase contract stated that square footage was approximate and must be verified during the inspection period if material to the buyer. This case reminds agents that contract language matters, but agents should still avoid careless statements about square footage. Boundary lines. Do not guess. An agent should never point to a tree, fence, wall, or rock and say that's the property line unless the boundary has been properly verified. Boundary lines should be confirmed by a surveyor or proper records. Guessing can create major liability if the buyer later discovers the lot is smaller, access is different, or improvements are encroaching. Affidavit of legal value and false information. ARS Section 32-2161 can create serious risk when a licensee participates in false or misleading information. One example is advising a buyer to put incorrect information on an affidavit of legal value. If a buyer is purchasing a home as an investment, the buyer should not falsely mark it as owner-occupied. That is not creative paperwork. That is false information, and agents should never assist in it. Legal hotline. Broker liable for agent's negligence. In one legal hotline scenario, an agent left a candle burning after an open house, causing $25,000 in fire damage. The seller's insurance company paid the claim and then sought reimbursement from the agent and broker. The likely answer: the agent may be liable for negligence, and the broker may also be liable under respondeat superior because the agent was acting in the course of business. Legal hotline. Seller misrepresentation about repairs. In another scenario, a buyer requested sprinkler repairs on the Binser. The seller provided an email and receipt suggesting the repair was completed, but after closing, the buyer discovered the repair was not done as promised. Even though the buyer completed the walkthrough and closed, the buyer may still pursue damages if the seller made false statements about the repair. Legal hotline. Missing air conditioning unit. At final walkthrough, the air conditioning unit was present. After closing, it was gone. The seller may be liable because fixtures and improvements are generally conveyed with the property, and the seller warranted the property would be in substantially the same condition as of contract acceptance. Legal hotline. Buyer's failure to investigate does not excuse seller fraud. If a seller knows a vacant lot is in a floodplain and intentionally fails to disclose it, the seller may still be liable even if the buyer could have discovered the issue through public records. The hotline material references Barnes v. Lopez, where the court recognized that a buyer may rely on a fraudulent and intentional misrepresentation and may not have a duty to investigate further after that misrepresentation. Closing thought. Negligence often starts with shortcuts, guessing, assuming, repeating what someone said, or trying to keep the deal moving. Best practice is simple. Verify what you can, disclose what you know, document what matters, and refer clients to the proper professional when the issue is outside your expertise. If Section 13 taught us what professional conduct requires, Section 14 shows us what can happen when reasonable care is missing. Online discussion question. Why is it risky for an agent to repeat a seller's statement that a property is on sewer without verifying it? Answer: because if the statement is wrong, the agent may have made a negligent misrepresentation that could have been avoided with reasonable verification. Question 2. Why should agents avoid identifying boundary lines for buyers? Answer: because boundary lines require proper verification, usually through a surveyor or reliable records. Guessing can create liability. Question 3. Why can a seller still be liable for fraud even if the buyer could have discovered the truth? Answer: because intentional fraudulent misrepresentation may allow the buyer to rely on the seller's statement, even if the buyer could have investigated further.